People shouldn't rely on assumptions. They should get answers to the right questions and undertake proper planning. The good news is all of this can be planned, everybody can be protected, and your wishes of what you want to have happen can actually be put into place. An example is if that home is jointly owned and one of the spouses passes, that home goes to that surviving spouse. If later that spouse passes, then that is going to go to their legal heirs pursuant to Michigan probate law or their estate plan if they put one together. That is a lot of times not what people want. What a lot of people do and can do by utilizing a trust that has properly been drafted, proper language, proper protections, and properly funded with that home, the surviving spouse can actually be given the opportunity to continue to live in that home as their home, protect that asset, insure that asset, care for that asset, continue to maintain that asset. But when they pass, that home can be preserved for the previous spouse's children. And a lot of times that's in fact what needs to be done. But that requires specific and proper planning, typically through a carefully drafted trust agreement. This provides a lot of security for both the surviving spouse and the children of the deceased spouse. Both of them are protected. There's a clear plan. All interests are preserved. Without this, we have seen all kinds of conflict, as you can imagine. Contests, disagreements, relationships absolutely destroyed over animosity or anger or resentment because proper planning wasn't done. And what a lot of times proper planning does is it preserves the relationship. It avoids the disagreement. It avoids those hurt feelings. It avoids unintended consequences that are certainly going to cause these types of situations. And this is going to create a very expensive, long, drawn-out probate process, all of which can be avoided. And if it can be avoided, it should be avoided. It just requires good information, proper planning, and execution.